very nice. Um, Today, we're going to talk for about an hour, followed by at least 15 minutes worth of slides. I need the Coase Theorem first, Hitesh. Um, Today, we're going to talk about property law and economics. And let me give you a brief introduction to what I'm going to say. This is a as you probably all know, this is a huge area. And I think you have all thought about some of the most important issues here. The traditional study of property law asks these questions. What things, or non-natural or non-material things, can one have a property right over or in? What rights and responsibilities does a property owner have? What may a property owner do to protect her property? Is there any duty to develop one's property? Or can one get benefits from just letting it sit idle? Can the government take, that is, compel the sale of private property? If so, when can it do that? And under what terms? Those are the traditional questions asked in property law, and there is an answer in legal scholarship for every one of those questions. In economics, we approach property law from a somewhat different framework. Our concern is the efficient use of society's scarce resources, and the role that property claims, it's mine, the role that property claims can play in fostering the efficient use of resources. So I'm going to focus on that issue here. And I'm going to begin by talking about it through the lens of the Coase Theorem. And let me explain to you again why we're doing this. I mentioned this yesterday, but I want to be sure that you understand why I'm using this as the introduction to property law and economics. I said that in economics, we want to view property through the economic idea of the efficient use of resources. And there is a strong argument that is made that I think you all understand. There is a strong argument to be made that assigning property rights to valuable resources will enhance their efficient use. The obverse of that contention is that failing to assign property interests in a valuable resource will damage society because those resources are unlikely to be used efficiently. The Coase Theorem helps us think or begin to think about these extraordinarily big questions about property and its role in enhancing societal well-being. The Coase Theorem starts by asking us, how important is it to assign the property interest to the right person or organization or group or society? And we're going to use the Coase Theorem to enter the world of property law by showing the circumstances that the Coase Theorem draws attention to allow us to identify the circumstances in which it is extremely valuable to assign a property interest correctly, and the circumstances where it doesn't matter how we assign a property interest. We can give it to anybody. And if there are low transaction costs, it doesn't matter. The property will be used efficiently. We'll talk about that briefly, not extensively, but we'll talk about it today. The next slide, please. Hitesh, just to remind you of what I talked about yesterday, I said that the idea of the Coase theorem was originated by Ronald Coase, who died about 15 years ago at the age of 102 or 3. Professor Coase only wrote 3 or 4 articles in his life, but my goodness, what wonderful articles they were. And one of them, The Problem of Social Cost, from the Journal of Law and Economics, Volume 3, beginning on page 1. That article is the most frequently cited article in law reviews of the 20th century, and I suspect the 21st century as well. The gist of the theorem that he articulates there, he doesn't really talk about this, but it's implied by everything that's in the article, is listed here. When transaction costs are 0 or very low, an efficient allocation of resources will obtain, regardless of the law. The law doesn't matter when transaction costs are 0. The law only matters when transaction costs are higher than that. Next slide, please. Just to remind you of what I talked about yesterday, there are 3 elements of transaction costs: the costs of doing an exchange with somebody, search costs, finding someone to bargain with, negotiation costs, once you've found them, how do you bargain about it, and then the post-bargaining costs, the enforcement or monitoring costs, to keep track of whether the transaction is being performed as you thought it would be, and guaranteeing that its terms are kept. Those, as I said yesterday, those terms, those costs, I'm sorry, those search, negotiation, and enforcement costs can be very high or medium-sized or 0, trivial. And it's important for us to have the tools to recognize how to identify what the level of transaction costs are. The next 3 slides talk about that, identifying the circumstances, but if I'll leave those to your reading, and instead, would you please flip to slide 8, Hitesh. If no transaction takes place, this is an extremely important point. If there's no transaction that takes place, where you think that none of the factors mentioned on slides 5 or 6, none of those is creating high transaction costs, why is an exchange not taking place? There is a very good reason, besides transaction costs, that an exchange might take place. And that's this important observation that there's no cooperative surplus. The resource is already in the hands of the person who values it the most. And the other person cannot offer him enough money for him to realize that he should give it up, exchange the right for money. There is no difference between the price the seller is willing to accept and the price the buyer is willing to offer. So it's important to remember that there are 2 reasons that transactions don't take place. Transaction costs may be too high, but also there may be no cooperative surplus. And we want to make sure that we don't attribute every failure to transact as being due to the presence of transaction costs. The other great reason is there's no cooperative surplus. And we have to be careful that we do not intervene in circumstances where there's no cooperative surplus. We should only intervene in circumstances in which there are benefits to both parties to be realized. Okay, next slide. I'm going to go through this example. It's a famous example. It's in our textbook, and it's an example that I made a mistake on one of the slides that I'll correct later. But consider a circumstance in which there are 2 property owners who are situated next to each other, a cattle rancher and a grain farmer. Their property boundaries are well established, but there is no physical boundary. There's no fence or ditch or any demarcation line, but they know where it is. So it's possible that the rancher's cattle might wander onto the farmer's property and cause damage to the farmer's crops. Let us assume, on the next slide, let us assume that the following things are true. The farmer could build and maintain a fence that would keep out the cattle for an annual cost of $80. The cattle rancher is a little bit more efficient at putting up a fence. He could build and maintain a fence between the properties for an annual cost of $60. If there's no fence, then the marauding or wandering cattle will reduce the farmer's profit from grain growing by $70 per year. Now, assume that the transaction costs between the farmer and the rancher are zero. One last thing that we need to say. Let's examine what happens. Next slide, please. Let's examine what happens under two different legal regimes. A regime of farmers' rights. If a farmer suffers damage from trespass to his property, he's entitled to compensation to make him whole. Trespassers are liable for the damage that they do. Or a regime of ranchers' rights. Cattle ranchers have no legal duty to supervise their cattle. If their cattle cause damage to someone else's property, the ranchers are not liable for compensation to the injured property owner. Now, let me point this out. Most legal analysis would not imagine a regime of ranchers' rights. They focus on causation of harm. And it's clear the causation of the harm are the unsupervised cattle. And that would be enough for the legal argument to make this a regime of farmers' rights. So the power of this example that I'm about to go through, I'm like a magician who's telling you how I do the trick. The power of this example from Professor Coase is that it's going to illustrate that it doesn't matter what the legal regime is when transaction costs are zero. The most efficient use of resources is going to occur. Okay, next slide. We need to examine what happens under the regime of farmers' rights, where the farmer has a legal right to be free from damage by wandering cattle. Will the farmer build a fence? No. The cost, $80 per year, exceeds the benefit, $70 per year. Will the rancher build a fence? Yes. It's cheaper to incur the $60 per year of building and maintaining the fence than to pay the farmer $70 per year for the damage that his cattle do. So remember, we're trying to see what the outcome, the efficient use of resources here happens regardless of what the legal regime is. So to warn you about what to expect under a different legal regime, we're going to argue that it doesn't matter whether we have a regime of farmers' rights or one of ranchers' rights. We're going to get the efficient outcome. And the efficient outcome here is that the rancher builds the fence. Why is that efficient? Because he's the most efficient builder of a dividing device, the fence, that prevents the $70 per year of damage. Okay, let's look at the next regime. The next regime is a regime of ranchers' rights. Under that regime, the rancher has no duty, no legal duty to supervise his cattle. And in those circumstances, what will happen? Next slide, please. Under this regime, what will happen? The rancher has no duty to supervise his cattle. Will the farmer build a fence? No. It's still not worth it for him to build the fence. The cost exceeds the benefit. Will the rancher build a fence? He has no legal obligation to do so, and it's going to cost him $60 to do that. But why should he incur that cost? Well, here's the trick. The farmer has an incentive to pay the rancher some price between $60 and $70 to build and maintain the fence every year. And here's the key. Both parties are better off. The farmer saves $5 in profit when the fence is built, and the rancher enjoys a $5 profit over his costs of building and maintaining the fence each year. So the outcome is exactly the same under a regime of ranchers' rights as it was under a regime of farmers' rights, namely that the most efficient use of resources will occur. The fence will be built, and the farmer will not have to incur $70 of loss every year. His profits will be less, but the efficient use of the two pieces of property will be identical. Just in the interest of being correct, on slide 16, I said under a regime of super farmers' rights that the farmer would be entitled to $240. It's not. He's entitled to $210. But I'll leave that as an exercise for you to work through. Well, I'm sure, I hope at any rate, that you'll have questions about the Coase theorem. But the point, let me reiterate, the example, by the way, illustrates exactly the situation in Shasta County, California, that I talked about yesterday between ranchers and farmers. In the eastern and the western parts of that county, the legal regimes were different. But as we've just seen, if the transaction costs between the parties are low, it doesn't matter. The more efficient use of the property is going to obtain. An implication of the Coase theorem that I want to draw out before I turn to the next topic is what happens if the transaction costs are not low? What happens if they're high? In those circumstances, the law has to intervene. And one of the insights of the earlier literature in law and economics that applied the Coase theorem to property law is to suggest that when the transaction costs are high, and they're usually high because the parties decide to engage in litigation about whether the farmer should be free from invasion by cattle or the rancher should have the right to be to not supervise his cattle. If there's litigation and the court suspects the transaction costs between the parties are so high that they can't reach an agreement, then the court has to perform what is called a hypothetical market transaction. The court has to take testimony to find out to whom the legal right is more valuable. That is it more valuable to the farmer to be free from invasion? Or is it more valuable to the rancher not to have to supervise his cattle? And they have to use the imperfect method of taking testimony in a court of law to decide what is best to be done. It's a second best solution, but it's the best we can do. And I hope that over the course of the last 40 years, I hope that these sorts of ideas about what role courts might play in legal disputes is being taught to law students in the United States and around the world, so that judges, as the dean said, or I'm sorry, the provost or president of the university said, the judges are aware of how to use economics to answer these different and difficult legal questions. To whom is the right more valuable? And will that person end up with the right if I do nothing, the Coasean solution? Or do I need to be mindful of the transaction costs between the parties and try to discover to whom the right is more valuable. Okay, now there's a lot in property law, and I'm going to try in the next half hour or so to go through the rest. I'll let you read the rest of the slideshow on the Coase theorem. And instead, Hitesh, let's go to the law and economics of intellectual property. One of the intellectual property has become one of the most exciting areas in the law. When I started teaching at the law school in the early 1980s, uh, there was no course on intellectual property. Patents, copyrights, trademarks, and trade secrets, the four principal examples of property rights in information, was taught as a part of the standard property course. By the early 1990s, there were two courses in intellectual property. And today, there are 4 or 5 different courses taught on intellectual property in law school. It's become a tremendously important topic. And here, I believe, is the economic reason that it has become such an important topic. Those of you who are economists know the famous solo growth model and the empirical attempts to use the solo growth model and the models of Paul Romer and others to try to estimate uh, uh, what is contributing to economic growth. Is it resource discovery or putting unused resources to work, or is it innovation? And almost always, those studies of the growth, the causes of economic growth in a society point to innovation, the area of intellectual property, as accounting for half and maybe more of the among the causes of growth. It's an extraordinarily important area. And I firmly believe that having an economic understanding of these different areas and why they have the characteristics they do is a tremendously important thing for lawyers, law students, and judges and legislators to have. So I'm going to try to explain very briefly to you why information constitutes something that needs special rules, special legal rules. Next slide, please. The underlying issue with regard to intellectual property is it's non-material. It may result in material property, a new machine, a new method of producing something, a new organization of a business enterprise. But the key for things that are protected by intellectual property rights is information. And as you all know, information is almost always a public good. By that we mean it's non-rivalrous in consumption. And that means, to quote the great Thomas Jefferson, the 3rd president of the United States, he who receives an idea from me receives instruction himself without lessening mine. In essence, that person can, once they get the idea from Thomas Jefferson, can pass it on to somebody else, and that person can pass it on to other people, and so on and so forth, without having to pay for it. And Jefferson concludes by saying that this is like somebody who lights his candle, that's what a taper is, who lights his candle from mine, receives light without darkening me. Both of our candles work. Information also has non-appropriability in sales. A customer can become a rival. They may pay you for the information, but then they can take the information and sell it on to somebody else. Why should I develop information and give it to somebody else if I'm not going to realize the benefits of that information? It's a real and important problem that information is a public good and needs special treatment. Next slide, please. The usual competitive, profit-seeking motives in an economy that serve us so well in so many different circumstances is not going to work with regard to information, with the result that there's going to be a suboptimal amount of information. We need to do something to guarantee that there is an optimal amount of information insofar as we can measure that sort of thing. We could subsidize the private production of information, or we could have the public provide all the valuable information. We do that and with regard to basic scientific information. You cannot patent information about what you've discovered about the stars through astronomy. So basic information is in the public domain, as we say. It's available to anybody for free. Another prescription is to give the producer of information an enforceable property interest in the information. So it becomes like real property, that is land, in that you have a property interest in your idea, and that gives you the right to proceed against other people who might be using your information without paying you for it, which is, all things considered, a very good thing. And the next slide, I'm not going to go through this. I take the example of a new pharmaceutical as an example of an important innovation that without the protection of intellectual property law would probably not be developed. But patents are not the only form of intellectual property. We also have intellectual property in creative endeavors, what are called in the law expressive activities, copyright. And copyright extends to written work, like the kind we all do, and it extends to dance and to music and to movies and all other forms of expressive activity. I'll tell you this because it's an interesting exception. There are two, to me, important things in life that are not protected by intellectual property rights, but are nonetheless valuable expressive activities. One is cooking. Recipes are by and large not protected by intellectual property unless they are written down in a cookbook and sold as a book. Another example is magic. I love magic tricks. I just love them. I don't know why, but anybody who performs a magic trick in my vision is a wonderful person. Magic tricks are not protected by intellectual property rights. And stage performances, for example, a comedian. What a comedian says is not protected by intellectual property rights. How do people protect their development of a comedy routine or of a magic act or as a recipe? Well, in the world of magic and in stage performances like comedy acts, there is an extraordinarily strong social custom. Remember, we talked about the role of social norms yesterday. There is an extremely strong social norm among magicians not to use somebody else's magic trick, or to use it only if you have asked if you can use it. The same is true of comedy. You don't just copy other people's comedy acts. There's a very strong social norm among comedians not to use somebody else's property. Okay, jump to 14, please. Slide number 14, Hitesh. This is that 14? Oh, I'm sorry, 8. I'm so sorry. That's my fault. Here are the things that I want to bring to your attention about property rights. There are differences between the rights that an owner of intellectual property has vis-a-vis the rights that the owner of real property has. The owner of real property, land, has that right forever, and they can pass it on to somebody else when they die. That's not the case with intellectual property rights, with one exception. Intellectual property rights are limited by time. In the case of patents, they're limited for 20 years from the date of filing for a patent protection. In the case of copyright, the copyright is limited to the author's life or the creator's life plus 70 years. Trademarks are an exception. For trademarks, which I'll describe briefly, there is no limitation. They can go on forever. This is one of the most intriguing aspects of intellectual property rights, and I do not think it is true. I think it is true. Please jump to number 14, Hitesh. I do think it is true that one of the great contributions that economics made to this area of property law is to try to point out the economic reasons for imposing limitations and the kind of limitations and the duration of limitations that are imposed on patents. We want to ask two questions. Why is the duration of patents limited to 20 years? Why is this a time-limited property right? And secondly, why don't we adjust the patent life to the social value of the patented innovation, invention, or improvement? If it's a minor invention, why don't we just protect it for a short time, 5 years? But if it's a major innovation, like the discovery of a cure for cancer, why don't we give that person a long life, 50, 100 years, as a reward for what they have done? I'll try to answer those questions relatively fast. And this is contained in the next several slides, so I'll let you walk through these slides at your own pace. We limit the duration of patents because a patent on an innovation or an invention or an improvement, a patent confers a monopoly right for 20 years. Nobody can use that invention or innovation or improvement without the patent holder's permission for 20 years. In essence, that property right is a monopoly. You might ask yourself, well, why isn't the ownership of real property a monopoly? It's not, because there are so many substitutes. But for patents, unless you can develop independently a substitute for a patented invention or improvement or innovation, unless you can develop easily an alternative, the patent holder becomes a monopolist. Now, I want to hasten to add that not every patented innovation is a monopoly. It could be relatively easy to invent around, as they say, to invent around a patent. In that case, there is no social cost to having the patent right for 20 years. So we give a property right in an innovation for a period of time as an encouragement to people to invest resources in developing something. The reward for them is this 20 years of exclusive ownership of the property. Why do we limit the time? Remember, it's an ex ante rule. We don't know whether the patent is going to be easy to substitute for or almost impossible to substitute for. And because we can't be sure whether the patent is going to be a monopoly, we just have to leave ourselves the opportunity to get out of a monopoly situation in the event that the patent turns out to be a monopoly. It's a sort of rough and ready rule. Okay, let me turn to the last topic. I want to say something about this. Why don't we have different patent lives for different patents depending on what the social benefit of the idea is? There's a long literature on this, and recognize this point. Having a patent duration of 20 years may provide an incentive for people to invest resources in developing things for which they will have exclusive ownership for 20 years. But if there is something that's very difficult to innovate or invent, that may require the extraordinary expenditure of resources, the 20-year patent may not be long enough to repay the costs of developing that incredibly important innovation. So we worry about the fact that very big social benefit inventions are not getting made because the duration of the patent life, it's too short to repay the investment into that thing. Recognize this fact. If you've spent $1 billion developing a new pharmaceutical, and by the way, that's a good estimate of the cost of developing a new pharmaceutical, $1 billion, and you've only got 20 years to realize, to get revenues from selling your pharmaceutical, that means the price of the pharmaceutical has got to be pretty high to compensate you for the investment of $1 billion in developing it and all of the other production and advertising costs, and still have a profit. That's one reason that it may be that patents are so, that pharmaceuticals are so expensive. They're expensive to develop, and the time during which the patent holder has to get his resources back to justify the expenditure is short. If patent life were 30 or 40 years, then the prices of pharmaceuticals might come down. These are complicated issues, very complicated issues. And I'm happy to say that because of the work of law and economics scholars, these issues about the optimal patent life are being talked about in public policy circles. And I think very important things will happen as a result of this. The slides, I'm not going to read them because we are short on time, but the slides between 19 and 23 discuss one attempt to talk about a way to encourage people to invest resources in innovations that would only affect a few people. The Orphan Drug Act is a fantastically interesting idea from the United States Congress. It provides an encouragement, and in some cases a subsidy, to pharmaceutical companies who will invest resources in developing something that affects 200 people only, 200 people or less a year. That's not enough people that you can realize a large stream of revenues to justify an innovation. But the Orphan Drug Act addresses this situation. Let's please go to slide 31. I'm going to try to go through this more rapidly so I can finish in 10 minutes. The second form of intellectual property right is copyright. And that copyright protection, that property interest, prevents the unauthorized copying of the products of expressive activity. The justification is the one we had for patents. Without some form of legal protection, people are not going to be able to realize the stream of revenues from selling their expressive activity unless that the product of that expressive activity is protected by a copyright. If anyone wants to copy your work without your permission, then why should you incur the costs of producing new work? You will not. You're going to be a starving artist living in a small room at the top of a house, rather than a successful artist, as you should be. Why do we limit and how do we limit the duration of copyright? Copyright is not good forever. But there are two things about copyright that I want to emphasize before turning to trademarks. The length of copyright protection in the United States, and I suspect around the world, has changed over the last 250 years. It's still limited, but it's gotten longer and longer and longer. Initially, around the year 1790 in the United States, copyright was only good for 14 years. Then later it was initially 14 years, but you could renew it for another 14 years. And then in the 1960s and 70s and 80s, judges and the Congress decided copyright should be longer. So today it's the author's life plus 70 years. Now, I don't want to defend exactly that rule on the basis of economics, the author's life plus 70 years. My principal point here is two. First, the duration of copyright of a property interest in expressive activity is like the duration of patents, limited in time. But unlike patents, the duration of copyright protection has increased over time. Why do we limit the time of copyright? The answer was given in a marvelous book written by Bill Landis and Dick Posner in the early 2000s, The Economic Structure of Intellectual Property. And the answer they gave to the question of why do we limit the duration of copyright was this very important point. Amazingly enough, artists today borrow from artists who came before them. It's the artistic equivalent of standing on the shoulders of giants in science. Artists today are reacting to what artists before did. And they take those ideas from before and make them more modern. I'll give you the best example I can think of this. It's on slide 35. Around the year 0, between BC and AD, or BC and BCE, or BCE and after, and the Common Era, there was a poet, a Roman poet named Ovidius. Ovid wrote odes and poems, and one of his poems, Pyramus and Thisbe, written in the 1st century of the modern era, was about two lovers from different families who were at war, and the problems that those two young people had in coming together, given that both of their families were at war and were deeply opposed to their getting together. Fast forward to the year 1594, 1500 years later, William Shakespeare writes the tragedy of Romeo and Juliet. That's about two young people, a boy and a girl, from different families, the Montagues and the Capulets, who are fighting and are opposed to there being any connection between those two families. That play by Shakespeare is a great, great, great play, but it borrows from a book that was published just before Shakespeare was born in 1564, a book called The Tragical History of Romeo and Juliet. Shakespeare was borrowing from Brooke. Brooke was borrowing from Ovid. And the last version of this, Leonard Bernstein and Stephen Sondheim in the 1950s wrote this wonderful musical called West Side Story, which is in essence Romeo and Juliet transposed to New York City and involving two gangs, the Jets and the Sharks, who are fighting each other all the time. But a boy from the Jets and a girl from the Sharks fall in love. And how does their love work out? Better than it did in Romeo and Juliet. But Bernstein and Sondheim, two of the greatest musicians of our lifetime, took this idea before and put it in a modern and different context, a musical, and New York City. What's the point? The point is that creators take older material and change it. They apply their own ideas. For example, I am told by one of my students that some playwrights in Israel and Palestine have set Romeo and Juliet in Palestine and Israel, with a boy from Israel and a woman from Palestine falling in love, even though those two communities are basically at war. The fact that people borrow to create their own work means that we can reduce the costs to expressive activity today by not requiring that people search all of history to find out what is copyrighted and only use the ideas that haven't been copyrighted, or the person is still alive, or somebody is protecting the copyright and they can bargain with that person. It's an astonishing insight that limiting the duration of copyright makes the backward looking by a current expressive artist. He or she doesn't have to look too far back because the duration of copyright is limited. The second aspect of copyrights that I want to say a word about is that they've gotten longer over time. Why? Basically because the cost of copying has fallen so low. And the lower the cost of copying, the longer the duration of copyright has to be in order to create an incentive to do something. I'll give you an example from the book that Bob and I did. The technology of computers grew up during the same time, the 1980s, the 90s, and the early 2000s, that Bob and I were doing the book and revising the book. Our publisher was eager to make a profit on the book, so they charged a high price for the book, more than $200 to buy the book. As we pointed out to our publishers, that makes the cost of the book too high for people in developing countries where the annual income may be $500 to $1,000. Nobody's going to spend $200 on a book, no matter how good it is, if your annual income is $500 or somewhere between $500 and $1,000 a year. So we pleaded with our publisher to reduce the cost greatly in developing countries. They wouldn't do it. And the reason they wouldn't do it was because they thought that if it was cheaper in India to get a copy of our book, then people in the United States would order the books from India at the low cost and sell them for a high price in the United States or in Western Europe. As we tried to argue to them at the time, you've got to figure this out somehow, because there is more change coming. And that change, of course, has come. And that is that there are PDFs, portable document format copies of the entire book. And the cost of copying in that case is zero. But Bob and I are thrilled by that, actually. We didn't do this to make money. We did it to try to spread ideas. And the cost of zero, we think, is a wonderful thing, because that means the ideas are going to spread everywhere. But our publisher was very upset and said, we ought to sue these people who are copying the book and distributing it for a nominal fee. And we said to the publisher, do not sue anybody. We told you about this problem 20 years ago. You should have known about it, and you should have developed something to deal with this. And they said, okay, we will not sue them, but we do not want to continue the copyright in your book. And Bob and I both said, great, we'll take the copyright. Please give it to us. So after some negotiations, we received the copyright for the book, and we're now posting it on the Berkeley website for anybody to download for free. And if we finish the 7th edition this coming year, we're going to sell that through Amazon at a very low price, somewhere around $20 for the book, because we can do that. And it's a great example of how the lowering the cost of copying has led to the legal response of making copyright longer. Okay, one last thing, and then I'm going to stop. Please jump to oh dear, to slide. No. There's so much more to talk about with regard to copyrights. Please forgive me. Oh, one thing I do want to say about, I'll do that later. Trademarks, slide 59, Hitesh. Trademarks are special marks that identify the product of the person who owns the trademark. In the United States, you can tell something's trademarked because at some point on the label, there is a line that's got trademark to Nagar Enterprises, and then a small t as a superscript at the end of that line. And that superscript T indicates that it has a trademark. Why do we have trademarks? Why is this intellectual property? Well, it's a method of providing an incentive for a producer of a product to develop a distinctive product that consumers will search out. And if that distinctive product can be easily copied, then the the person who developed the product is not going to be able to realize the benefits of having invested in making his or her product distinctive, something that consumers value. And so the legal response is to give that person a property interest in the name and the identification of their product through something called a trademark. How long does this trademark last? It lasts forever until the product disappears or is absorbed by somebody else. Why is there no time limitation? Because we think that these are all products that are being produced in competitive markets. So competition to the owner of a trademark can arise, even though there are trademarked mattresses, foods, and other things. And as a result, we don't care about the trademark lasting for a long time. Trademarks come and trademarks go. And I want to tell you an interesting, this is the last thing I'm going to say before I stop. Well, that's not quite true, but almost true. There are some things about trademarks that I want you to know. If a trademark is too successful, what's too successful? It's so successful that people confuse the product that's been developed for an entire class of products. For example, this is one of the best examples I can give you. The word aspirin. Aspirin was originally a trademark of the Bayer Corporation, a German corporation. The ingredient that makes aspirin is called acetylsalicylic acid. But the Bayer Corporation called that development aspirin. That trademark is protected in Canada. So if you go into a store and ask for aspirin, they will give you the product by the Bayer Corporation. In the United States, if you go into a store and ask for aspirin, they'll give you any aspirin they have produced by anybody, because it's not trademarked. It's not trademarked in the United States because during the First World War, we took the trademark away from Bayer Corporation because they were a German corporation. We were fighting the Germans. And it's not trademarked here. It is trademarked there. Other examples of things that are trademarks don't exist because the name has become synonymous with the product is the word Xerox. Xerox was a corporation that developed the copier that we put something in, close the lid, push a button, and we'll get a copy. That was produced originally by the Xerox Corporation. But today, if we ask for a Xerox copy, we don't mean get a product of the Xerox Corporation and make a copy, we mean make a copy, make a photocopy. That name Xerox has become identified with any machine that produces a photocopy. And therefore, because it's confused with a product class, it can't be trademarked. Kleenex, another example. Scotch tape, another example. Coke, the soft drink, is having a difficult time protecting its copyright because in many parts of the United States, when people order a Coke, they don't mean the product of the Coca-Cola Corporation of Atlanta, Georgia. They mean any soda cola, any cola. Okay. Trade secrets are discussed in the last three slides. An extremely important topic. I urge you to look through it. It's a different form of intellectual property that people try to protect by having non-disclosure agreements with their employees or other restrictions that prevent an employee from telling somebody else how business is done inside a corporation. Okay, there were two other things I wanted to discuss, but I'll leave you to get on reading. Takings and regulatory takings, extremely important topic. And finally, the anti-commons. The anti-commons refers to a situation in which property rights have become too small. They've been sliced into too many small pieces. And just to give you an example, I don't have my cell phone here, but if I did, I'd hold it up and I'd ask you, how many patents, how many patented parts do you think are in a mobile phone? The answer is more than 300. Think about the administrative costs, the transaction costs, if you will, of getting the permission of 300 different property owners, patent owners, to allow you to put together a device that uses 300 different patents. It's a huge problem, but somehow phone manufacturers have surmounted it. I've gone on for too long. I apologize, but I'd be happy to answer any of your questions. I see there are a couple. Thank you, Prasad. Oh, isn't that interesting? Akshay Thakra points out that Tomorrowland is a trademark in the USA that goes to the Disney Corporation. Tomorrowland in Europe is a trademark for a music event only, not for everything that's involved in Tomorrowland. It is one of my great regrets in life that I have only been to one Disneyland. That's the one located close to Los Angeles. Our grandchildren have been to 2 or 3 of the Disneylands, so they know much more about it than I do. Anyway, I'd be happy to answer questions. Dr. Sapatnikar, what are my views on IPR as a solution to public goods problem or concept? By IPR, you mean intellectual property rights? Is that correct? I think so. Well, it is one possible solution. If I had had time, I would talk about other solutions for public good problems. Public subsidy of private provision is sometimes a good solution for a public good problem without assigning property interest. A great example of that are COVID vaccines, at least in the United States. The Trump administration, I won't talk about it because my blood pressure will increase, and I don't want that to happen. But one of the things the Trump administration did correctly, and I don't think Donald Trump had anything to do with this decision, I think it was wiser people, they produced this amazing set of vaccines for the COVID that came out at the end of 2020, at the beginning of 2021. And here's what they did that was just absolutely astonishing. um, they realized that it would take a lot of time for firms that wanted to produce a vaccine to get the vaccine ready. And the administration wanted to reduce that time for development. The first idea for the RNA-based vaccines that eventually appeared, those first RNA vaccines were thought of in January of 2020. Think of that. That's before the public health problem really became evident. The vaccines came out at the end of the year, 9 or so months later. That's light speed for the development and marketing of a complex pharmaceutical. How did it happen? Not by assigning property rights, but rather by dealing with the public goods problem of a vaccine that provides a public health benefit to everybody in two ways. First, by making the vaccine free to everybody. But secondly, and more important for the question that you asked, Dr. Sapandakar, which is a very, very good question. The other thing they did was to uh, uh, promise 3 developers, and only 3 developers, that if they would make their, if the vaccine passed the first test of the 3 tests that have to be undertaken to be marketed. We have an organization called the Food and Drug Administration that tests the manufacturers of pharmaceuticals have to go through 3 levels of tests. We promised that if they got through the first level, the easiest level, the United States government would guarantee to buy all the vaccines they could produce. So that removed the risk of slowing down the development of the vaccine. And just that promise of buying millions of doses was enough to get the manufacturers to produce them in huge quantities by the end of 2020, with the result that by the middle of 2021, approximately 2/3 of American citizens were inoculated against COVID-19, and the deaths from COVID-19, which were running at the rate of 5,000 a day, have almost disappeared. So the point is, you don't have to assign intellectual property rights. You can achieve the results in other ways. Public subsidization is one of them. Good question. Here's a question from Pratik Kumar. Since the objective behind granting protection to intellectual property rights is to allow for recovery of the cost of invention, why haven't we created a system that links the life of intellectual property rights, more specifically patents, to recovery of the cost of invention? Um, um, that's a good question, a very good question. Um, I think the answer, I used to tell my students that when I ask them any question, somebody should answer this: transaction costs. And I think that this is I think the reason we don't have variable lengths of patent, depending on how much money has been invested, is, first of all, we don't want to reward an inefficient producer, somebody who incurred a lot of costs of invention to produce something that could have been produced for a much smaller expenditure. And the transaction costs of having a government agency that looks at the costs of invention and decides whether they are legitimate or too much, those administration costs are going to be high. Let me point out one other thing. This answers this question, and I think the previous one. One of the things I did not talk about, but I think is an incredibly important thing, is using rewards for people who develop very, very important innovations or improvements or inventions. And that's been done in the past. For example, in the late 1700s, smallpox was a tremendously horrible disease that spread rapidly in places. And the United States government, and I think the government in the United Kingdom also, announced a reward. They would give a huge sum of money to the first person who developed a method of inoculation against smallpox. There's a very famous story, it's true, in a book called Longitude, or as they say in England, Longitude, uh, by Davis Sobel. D-A-V-A is her first name, and her second name is Sobel, S-O-B-E-L. In that book, she discusses the United Kingdom's deep interest in finding a good way to measure longitude. Longitude are the lines that go north and south around the Earth. Latitude are the ones that go around the Earth, east to west. The equator is a good example of a latitude measure. We knew how to measure latitude, but we didn't know how to measure longitude. And the British government announced in the 1840s, I think it was, a huge monetary sum that would be awarded to whoever could come up with the best way to measure longitude. Eventually, it was awarded to a clockmaker who developed a method of using clocks to determine longitude. We could do the same thing today. And in a way, we are doing things like that for diseases like cancer and heart disease. We have research institutions that take donations, but the government could announce a $15 million prize for the first person to develop a cure for heart disease, for example, that had the following characteristics. We did that too, by the way, to encourage. We announced a public award of millions and millions of dollars for the first person to develop a way of sending passengers into space. And that prize was awarded 10 or 15 years ago. Anyway, prizes, rewards. I mentioned those in the slide presentation that you should have access to. Okay. The patent thickets problem. Dean Nagar asked that. I take it that this is the problem of having so many patents that they create a fence that prevents people from getting through and developing other things.
Yes, sir.
I think that's an excellent question, and I don't know enough to answer this really, but I hope that there is a regulatory or an antitrust issue that can identify that. One of the sections that I didn't get a chance to talk about that's a very important one is the governmental taking of private property. The government usually has used that power. I think every government I know of has the right to do that. The government can take private property for a public use if it pays just compensation. But there's nothing in the taking statutes or in the federal government, the constitutional provision on taking, that would prevent the government from taking intellectual property. And it has threatened to do so. You may remember some time ago in the United States when there was a disease called anthrax that was being spread among public policy makers in Washington by somebody who was putting anthrax powder in envelopes and mailing it to prominent people, causing terrible illness to them. It turned out that there is only one pharmaceutical produced to treat anthrax. And the federal government, for the first time in my life, announced that it would take that pharmaceutical. It would pay the producers a compensation, but it would take that formula for the cure for anthrax and put it in the public domain and let anybody use it. So it would be a low-cost way to deal with anthrax. They didn't do it because they found the person who was doing that and arrested him, and he was tried and now is in prison. But I think with regard to the patent thickets problem, one possible way of dealing with that is to have the government take some of those patents so as to provide a route through which what are called follow-on developers could get into that area and develop follow-on patents to the ones that are being protected by the patent thicket. Is that what you had in mind, Renita?
Yes, Professor, yes.
Okay.
That is patent thicket, yes. I was all, I mean, maybe some other discussion, like, do we see reflections of this in the patent law? I don't think we do.
No, I don't think so either.
No,
and it's a good point because I would love for somebody who's younger and has a career to worry about to take up this topic of the taking of intellectual property and provide us with a model and some guidelines for the governmental taking of private property and intellectual property every now and then. I don't, there, to my knowledge, there is no writing on that issue, and there should be.
Thank you, Professor. Thank you.
In India, you have compulsory licensing, which we don't have in the United States. And by compulsory licensing, I think, Dr. Kumar, you mean that the holder of a patent is compelled to license other people to use it. That is another solution to the patent thickets problem. And in the United States, they've been very reluctant to impose those duties on intellectual property owners. But I don't think that's a less invasive. Compulsory licensing is less invasive than governmental taking of the patent, and it's something we ought to consider doing. It's a very powerful tool for preventing patent thickets or a monopolistic patent from preventing people getting through to be able to produce follow-on patents. Good question. I'd forgotten about compulsory licensing. Well, I think I've exhausted you. I'm sorry. It was too much material in too short a time. But please, if you get a chance, read the slideshows. They're full of what I hope are interesting examples of property law, and that will, I hope, address some of the questions you have.
Professor, that example on copyright, from Romeo and Juliet, it was amazing. The example on copyright taking from Romeo and Juliet was amazing. We have many such instances, examples in India also.
In literature, mostly?
In literature, yes. Popular literature, very popular literature.
I never thought about that sort of thing. I never thought why they limited the duration of copyright and why it had increased till I read the work of Bill Landis and Dick Posner, two of the giants on whose shoulders we all stand. And what they said answered so many questions that traditional law professors would typically in a copyright class would just tell the students what the law is and what arguments have been used to address some of the issues arising under copyright. But they wouldn't have explained to the students, probably, maybe they would, have explained to the students why there was a time limitation on copyright and why that had extended over time. And I think Landis and Posner have provided Nobel quality work to explain those limitations. That it makes a great deal of sense. that work was one of those things where you read it and you think, oh my gosh, this is just fantastic. Anyway, there's it's one of the wonderful things about this area of the law, namely that it is filled with marvelous insights into the law that I think they will serve as fuel for future scholars. And I wish that when my time comes to leave this planet, I hope I can sit on a cloud up in the sky and follow the literature to find out the amazing things that people are going to be doing with some of these concepts that were developed by law and economics over the last 40 years.
Professor, the cloud can wait for a long time. There is so much to do right here.
I know.
The
Well,
cloud journey can wait.
You're all going to be very busy for a long time.
And we will need you.
Tomorrow we're going to discuss tort law and economics, which I find is a fascinating subject. And I'll tell you why tomorrow. I don't need to tell you now, but I look forward to it. Thank you so much.